Oyez, oyez, oyez. The Honorable Supreme Court of Texas. All persons having business before the Honorable Supreme Court of Texas are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. We'll hear argument in two cases this morning. First is 23-555. PUC versus RWE Renewables Americas from the Third Court of Appeals District. And then 2436, Carl versus Hillcore Energy, a certified question from the United States Court of Appeals for the Fifth Circuit. We've allotted 20 minutes for each side in each case, and we'll take a brief recess between them. The arguments are being webcast this morning live and should be available in the archives later on. We're ready for argument in 23-555.
May it please the court, Mr. Heifel will present argument for the petitioner. Mr. Baccaris will present argument for the amicus. Petitioner has reserved 5 minutes for rebuttal. Mr. Heifel will open with the first 10 minutes, and Mr. Heifel will present the rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. The most straightforward way for the court to resolve this case is to hold that the Court of Appeals lack jurisdiction because the order is not a rule under the APA or PURA. So I'd like to start there, and then, time permitting, turn to why the order was within the Commission's statutory authority. The order is not a rule because it just approves protocols already adopted by ERCOT. And in arguing that the order is a rule, respondents make a fundamental mistake. They conflate ERCOT's NOTA protocols with Commission rules, but these two things are distinct. For about 20 years, ERCOT has had its own special process for developing, adopting, and revising its protocols. And this court has already rejected the argument that respondents now make that all ERCOT is really doing is making recommendations to the Commission. Instead, in CPS Energy, this court recognized that ERCOT adopts, establishes, enacts, and enforces rules as part of its, quote, uniquely governmental function. That's at pages 616, 623, and 626 of the court's opinion.
If ERCOT is the one adopting the rules, is ERCOT's rulemaking process subject to the APA?
It's not, Your Honor, for a couple of reasons. First, it's not a state agency, and so the market rules that it promulgates doesn't satisfy the APA's definition. And second, and more fundamentally, this entire space is outside the APA. And the reason that we know that is, again, we have this distinct ERCOT process established in Section 21 of the NOTA protocols. It has many of the same procedural safeguards as the APA, but knowing that this process has existed for all of this time, the legislature recently reaffirmed that ERCOT it must have its own special process. We see that in PURA section.
Right, so a rule couldn't take itself outside of the APA, right? But
that's
the
correct.
argument would be that this is it G1, or it's one of those new G- provisions that.
Yes, Your Honor. So the legislature in 39151G-6 said that ERCOT must have its own process, and that's just recognizing what.
Let me ask you. So if this rule is such that, or the procedure is such that ERCOT is going to be complying with all the procedural safeguards that are necessary to protect the public, whomever, then what was the point of saying that the PUC has to approve it?
So
if those safeguards were already going on over here, and the purpose of the APA is to really do the same thing in terms of procedural safeguards, so why did they say that you had to get this approval?
My understanding is that after Winter Storm Uri, the legislature felt that they needed to ensure that the Commission was overseeing what ERCOT was doing, that there was transparency. Of course, the Commission was already doing that, but the reason they added this provision is just to make sure that the Commission was doing that oversight before the protocols that were adopted by ERCOT already take effect. And
so you haven't like an objective group of professional experts who know about all of this, sort of? Is that the idea?
I think the idea, Your Honor, is that ERCOT has extensive technical expertise. Right. So they're in the weeds. They're working in a collaborative process with market participants. What the commission has is sort of big picture goals, big picture understanding of how the market is going to operate. And so, for example, in NPRR 1186 is a recent example where the commission declined to approve protocols that ERCOT had adopted, and they remanded the protocols back to ERCOT for further consideration. That's how this process is intended to work out. And so, as Calpine explains in its amicus brief, the process allows a market participant to challenge an ERCOT protocol revision, first in ERCOT, then in the commission, and then in the court. So we're not arguing that the protocol revisions aren't subject to judicial review. They are, but there's an orderly way to get there, which, for example, produces a record, which we don't have in this case. The commission's role in that process is laid out in 16 Texas Administrative Code, Section 22-251. And after the commission makes a determination about a challenge to a protocol revision, the commission's decision is then subject to judicial review in a trial court for substantial evidence as a contested case under PURA sections 15.001 and 39.003. What respondents, and respondent RWE is well aware that this process exists and has existed. In fact, RWE initially participated in the protocol revision process with respect to the very protocols at issue here. We see that in the petition appendix tab P. But what respondents are now trying to do is they're trying to ignore the rest of that decades-old process and use a direct appeal from a commission order to collaterally attack the substance of the protocol revisions themselves. We would ask that the court reject that attempt, and if the Court of Appeals and respondents are correct about how this whole process works, 3 serious consequences will follow. First,
before you get to that, I guess I'm not understanding why you're not embracing the APA as applicable to and satisfied by the nodal protocol amendment process that ERCOT goes through, because Utilities Code 39151D says that the PUC can adopt and enforce rules, or it can delegate to an independent organization responsibilities for adopting or enforcing such rules. So that seems to assume that that what's going on in ERCOT is rulemaking.
so the question of whether ERCOT's process under Section 21 satisfies the APA is a distinct question that's not before the court, and the reason it's not before the court is because of the decision that respondents made to take a direct appeal under PURA of the commission order. So the question here is whether the commission order satisfies the APA. We aren't contending that it is. And that's why this case is so important, because if respondents are correct about how this works, every time going forward after ERCOT has gone through its entire process, then the APA on the back end is going to have to go through costly and duplicative APA rulemaking if the order itself is a rule.
You're saying we don't even really have to decide whether the ERCOT process is a rule and whether it complied with the APA or not, because they just challenged the wrong thing.
That's correct, Your Honor. And the second consequence, if the Court of Appeals and respondents are correct, is that now every time the protocols are revised, and this happens frequently, it's going to mean a direct appeal to the 15th Court if somebody is unhappy with it. And it's easy to see how the 15th Court's docket is going to quickly become flooded with direct appeals under PURA from every ERCOT protocol revision.
You don't have to worry about them too much. They're not going to have enough work anyway. So.
Be that as it may, it still seems like an unwieldy process, and again, it doesn't even produce a record, as we see in this case.
If the PUC had suggested a modification to the nodal protocol as it can, would that order be reviewable as a rule?
Not that order, but the underlying revision. Once it went back to ERCOT considered the modifications required or suggested by the commission. And then it went through and there was the ERCOT board vote and it was adopted by ERCOT. Then it's subject to challenge just like any other protocol revision. So it doesn't somehow evade review. It just happens beginning at the ERCOT phase and then going through the commission and then on to review as a contested case. And the third result here would be that every single protocol revision that has been adopted and approved under the post-winter storm Uri regime would be presumptively invalid. And the reason for that is that all of the commission orders that have approved the protocol changes are much like this one. They're not APA rulemakings. ERCOT says in its amicus brief that that's more than 150 revisions. My understanding from the commission is that that number is now well above 200 and it continues to grow. We're talking about hundreds, maybe thousands of pages of binding market rules, and the effect on Texas's energy market of suddenly having all of those protocols presumptively invalid is difficult to imagine.
Is ERCOT's authority here a delegation of the PUC's rulemaking power?
Yes.
Is that the authority that they're exercising?
Yes, Justice Boyd, as the legislature specifically enables them to do in 39-151D.
But it is a delegation of the commission's rulemaking power, not some other power, but actual rulemaking power.
That's right, Your Honor. The legislature is the one that created this entire scheme. It's important to remember that this isn't something that the commission has tried to do through its own rulemaking power. The legislature requires that an independent organization be certified, and then it allows the commission to delegate rulemaking.
I understand based on the respondents, the way the respondents chose to challenge this, why the question that Justice Busby raised may not be before us. But on the other hand, if we start with the proposition that what we're talking about here is rulemaking power that vests in the commission but is then delegated, then it must be the case that the APA applies at one place or the other, right?
Well, except that that would defeat the purpose of the delegation. But I take Your Honor to mean that you only need one APA. You don't need a double APA, right?
Well, so in other words, the commission cannot delegate power it doesn't have, and it doesn't have power to adopt rules without complying with the APA. So if they delegate that power to ERCOT, then the power is to adopt rules in compliance with the APA, is it not?
Mr. Chief Justice?
Yes.
Yeah, and that, even if that's the case, Your Honor, it may well be that ERCOT's process satisfies the APA. That's not something that we've briefed because we've considered this as a challenge to the order. But I can tell you that it has many of the same protections. And in fact, in some ways, it's even better than the APA because it's a collaborative process. It's not like the APA where people just shoot comments to the agency and then the agency makes an arm's length decision. This is actually a collaborative process, and that's why these protocols are so often uncontroversial.
Any other questions? Thank you, Mr. Cobb. We'll hear from ERCOT.
Thank you, Chief Justice, and may it please the court. I'd like to just start by addressing Justice Boyd's question that Mr. Heifel was just answering. The way that the legislature has decided to make this work, especially in the aftermath of winter storm, is by saying that the PUC does its rulemaking. Generally speaking, what we have from the PUC is something like this long that is a general policy, and it tells ERCOT to implement, say, this is a recent example, an emergency pricing program. The PUC takes that, turns it into 100 words. ERCOT then uses its stakeholder process, which harnesses the expertise of the market, of its own great number of experts, and turns that policy into 100 pages of binding rules that actually say, here's how this is going to function, here's how the prices are going to be settled. And the legislature has made a judgment, in particular right after the storm, when ERCOT was under a microscope, that process probably ought to be outside of the APA. So it's certainly true that when the PUC adopts rules, it must do so under the APA. But the legislature said when ERCOT adopts protocols, it does so using a formal process that is set forth in its rules.
And where does the legislature say that?
It says that in 39.151G6. It directs ERCOT to use a formal process. And that is the process that's in Section 21 of the protocols. And that has 3 different opportunities for public comment. There's several different meetings of various ERCOT subcommittees, and then the board. By statute, the board must allow public comment. That's 39.1511B. And so what you have is a specialized process that complies with the due process notice and rulemaking, notice and comment requirements of the APA, while differing perhaps in some of the specifics. And then you have the second layer of oversight, which in 39.151G6, the legislature says, as it always has, that ERCOT's rulemaking is subject to commission oversight and review, and then they added this phrase, and must be approved by the PUC before taking effect. That clearly links it to this notion of oversight. And the approval process is an oversight function. And we see that made more clear in 2023 in the last sentence of G6, which says what the PUC may do as part of this oversight function. It may approve, reject, or remand with suggestions, with suggested modifications to ERCOT protocols adopted by ERCOT. Now, I think that phrase
Historically, has the PUC rejected rules, amended them, done different things with them in response to what ERCOT does?
So it, as Mr. Heifel said, it did very recently, within the last couple months, in a big case that received a fair amount of attention regarding batteries in NPRR 1186, say, we don't quite like this policy, how you've formulated it, go back and do it again with these modifications. And there have been other examples over the years, but the reality is that because of the ERCOT stakeholder process, where consumers, every market segment is involved in this process, you have rules that ultimately are palatable to most of the market.
You mentioned the stakeholder process.
Yes, ma'am.
Are market participants separately bound under an agreement to comply with ERCOT processes, or is it just completely a creature of delegation from the PUC?
So there's a specific provision, 39.151J, that specifically requires market participants to follow all ERCOT protocols. And then there's also what they call the standard form market agreement that makes that also a contractual obligation.
There's a contractual obligation.
There is.
Historically, if the PUC doesn't like what ERCOT comes up with, does it send it back to ERCOT to redo it, or does the PUC itself make changes to the rule before it goes into effect?
Thank you for that question, because that was the point I was going to try to make to one of Justice Bland's questions. So this phrase suggested in 39.51G6 I think is very important, because if, as the Court of Appeals held in respondents' claim, ERCOT was merely proposing rules for the PUC's adoption, that is exactly what would happen, Justice Blacklock. You would see the PUC adopt a rule as modified. Instead, it merely suggests changes to ERCOT, and then ERCOT is the one who ultimately adopts the rule.
But if the PUC doesn't like it, I mean, they could just withdraw the rulemaking authority from ERCOT and do it themselves. So it's not like there's really a constraint, right, on what the PUC can tell ERCOT to do.
Chief Justice, may I answer that?
May.
The question is whether there's a constraint on
Right, I mean, the PUC, I hear what you're saying about suggested, but the PUC has a big hammer to basically either tell ERCOT, do it this way, or we'll do it ourselves, right?
Certainly, the PUC has essentially plenary control over ERCOT, but what the PUC lacks is the technical expertise to actually craft the rules that ERCOT does. I mean, if you look, for example, this protocol that is at issue in this case is part of Section 6 of the protocols, which is like the operations of the real-time market, not even the settlement of that. That's 500 pages, just that section. So the PUC simply doesn't have the technical expertise and resources to make those rules itself, but ERCOT does.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Kuhn will present argument for the respondents.
Mr. Chief Justice, and may it please the court, this case involves two major policy decisions made by the legislature. First, through PURA, when it ordered deregulation of the wholesale electric market and ordered that prices be set by competition, not by regulators. Second, through the APA, when it determined agencies cannot adopt new or amended rules without first allowing for public notice and comment. Since deregulation, the PUC had followed both of those policy determinations. Now, it argues it doesn't have to. This case is really about protecting the market and reining in the agency's overreach. I'd like to briefly talk about both PURA and the APA if I'm able to. We haven't talked much about the PURA, but I'd like to begin there if that's okay with the court. More than 2 decades ago, the legislature made an important policy decision to unbundle vertically integrated monopolies of utilities and establish competitive marketing. Under the old scheme, you used regulation instead of competition, and the legislature decided that that had to end. So what it did was it decided under PURA that the production of energy was no longer a monopoly, warranting the regulation of rates, and it amended PURA to say prices should be determined by customer choices and the normal forces of competition.
What if the ERCOT and the PUC decide that that way of doing things may not always keep the lights on, and they believe they have a more fundamental obligation to keep the lights on than they do to follow the competition directive? Are they powerless in that situation to depart from the competition directive?
I think there's 2 parts to your question. First, about keeping the lights on, right? And they made this argument in the Luminant case. The keeping the lights on clearly was done through the load shed, which is not the issue before the court or the pricing issue. If they believe that they need an amendment to PURA to allow them to do pricing in some circumstances, the answer to that is to go across the lawn and talk to the legislature.
So your position is under current law, they are powerless to depart from the competition directive if they believe it is necessary, if they believe they have to do that in order to keep the lights on?
Well, look, if there's a rule, there's a protocol, if your question envisions that essentially the market fails, right, there is a protocol to deal with that. It's Protocol 25, and it's basically you stop the market and restart it. And it requires them to make whole payments during that period. But it didn't happen during Storm Uri because the market didn't fail. The market was acting exactly as it was designed. Now, the question is...
So my question isn't whether they're right or they were right at any point in time or even in the hypothetical that they are right, that they have to do something to keep the lights on. My question is if in their judgment they believe they have to do something that violates the competition directive in order to keep the lights on, is it your position that they are powerless to do that?
I mean, yes, Your Honor. Your question is, in essence, your question is, if they disagree with the legislature's determination, can they do whatever they want? And the answer is no.
Well, they also have a directive to maintain the grid. And the question would be which, as between the competition directive and the overarching responsibility to keep the lights on, which is superior when in their judgment, the two come into intractable conflict.
I'm glad you brought that up.
Frankly, it seems to me that keeping the lights on has to be the superior directive
I appreciate
for any of this to make practical sense. But tell me if I'm wrong.
Right. No, I appreciate the question. And it goes back to a question that Justice Bland asked during the Luminant argument. And if you look at, this is 3901D that talks about regulatory authority. And it talks about shall authorize or order competitive rather than regulatory methods to achieve the goals of this chapter to the greatest extent feasible. And I think during the last argument, Justice Blaine, you talked about the idea, does that mean reliability is more important than competition because competition is limited to be feasible? But under the last, under grammatical rules, which were talked about in the last argument, what the legislature is saying there, and there's multiple goals of the chapter. They also talk about, because they cite the 39101, which talks about both reliability and reasonably priced energy. Those are clearly goals, right? But if you look at the material, when you adopt this system, like the Brattle report talks about it, right? There is an expected failure rate. You're going to go into load shed. The acceptable rate they talk about in the industry is 1 out of 10, which means you're going to have a load shed event maybe 1 every 10 years, right? In the old system, in an old regulatory system, you could have structured it such that you're going to have extra capacity. You're going to pay people not to produce, right? When the legislature chose to switch to the market-based system, it made the decision that there are going to be times when the market is going to require load shed. That's part of the system. It's in the Brattle report. They talk about it in all of these materials, right? It's
The
going to
market
happen.
doesn't require the load shed. There's a directive for load shed. And isn't that as much engagement in the market and as a pricing directive?
Right, Your Honor. Well, the load shed, what it does is it, essentially the way I would think about it is it shrinks the field necessarily because you don't
It
have enough.
reduces demand. If you talk about
Right.
pricing, as a result of supply and demand, load
Right.
shed reduces
But
demand.
but the market continues to function, right? The market is
But
functioning.
artificially, because there's been a directive.
Well, all of
to
these,
engage in load
all of
shed.
these, right, Your Honor, all of these interactions, all the things they could do like rucking or load shed or any of those things, it does suppress price naturally, and that was recognized and why the price adders were added. But in none of those circumstances did they replace the market, right? If you remember, when they originally were arguing this case, it was with the idea that, they weren't replacing the market. It was just it was a technical glitch they were trying to fix. And now, in this case, they've admitted, right, their real argument is, well, there's not a market anymore, and we have to step in and replace it. This is how the market works, right? And the legislature said you have to do it this way. And to go back to your question, Judge, if they want a gap filler, right, you talked about this in track phone. If you want a gap filler because you say this isn't acceptable, right, we need to have this power, you have to go to the legislature to get that. The
And
agency-
otherwise, they just have to let it fail.
Well, it doesn't fail, Your Honor.
But if that were their judgment that that's what's gonna happen, that's what they'd have to do? Or-
Well, no, they ordered load shed.
But
That's what
if they thought load shed wasn't gonna be enough.
Your Honor, the only reason I'm hesitating is,
No.
you just order more load shed. The idea is you have to balance it, which is, when they.
Shut it off manually.
That's how the system works, right? Whether you have a market system or not, right? You have to balance it. The way you do that is through load shed.
The implication of what you're saying is that if they find themselves in a situation where there's something they need to do in a crisis to make sure that more Texans have heat and power during a storm, that there are circumstances in which they cannot do it. They're not empowered to maximize electric availability to the people of Texas because they're hamstrung by the competition directive, and that the competition directive essentially overrides the reliability and usability.
No, I just
directive.
disagree with the premise of the question, because I think it fundamentally rejects the decision of the legislature, right? This is like the equivalent of
No,
the
but
antitrust case.
my point is, I guess what you're saying is that the legislature decided, in your view, the legislature decided that in a crisis, competition may very well be more important than
No, Your Honor.
maximizing.
No, Your Honor.
keeping
My
the lights
point
on.
is that the legislature decided that the best way to get more power, cheaper power, more efficient power is through the market-based system. The question you're asking assumes that that's wrong. That the agency can step in and say, in 1999, when you decided, legislature, to switch to a market-based system, you're wrong. And we're going to assume power because you made a mistake. And that's not an ability the agency has.
Well, the response to that would be, that may be right and that may be feasible and doable in 99.9% of the circumstances. But if we can even imagine a circumstance where tying ourselves to the mast of the competition directive results in some kind of catastrophic consequence for the people of Texas, it's hard for me to imagine that anybody could take the position that the PUC is required to just go down that.
It's an
that
apples
road.
and oranges question, Your Honor, right? We're not going down with the ship. The point is that the legislature decided, rightfully so, that a market-based system was preferable. And it worked. And it's worked for 2 decades.
About half your time's expired. Can we get to the question of whether a PUC
Surely.
order is a rule when it's an order that approves a ERCOT protocol enactment or modification? I quickly searched the Texas codes for the phrase "is not a rule." And it shows up 7 times in the Texas codes where the legislature has expressly said that a particular order or opinion issued by an executive branch agency is not a rule under 2001 or is not a rule for purposes of 2001. They certainly have the power to do that, the legislature, to say that without regard to the APA, this particular kind of order or an opinion is not a rule. Now, that phrase does not show up in PURA. They haven't done it there, but why haven't they implicitly done it by the structure that they've created?
They've done the opposite, Your Honor, and I appreciate the question. So, a couple of things. First, to go back to whether or not, they are challenging the APA, or whether or not this complies with the APA. They did challenge that, and they lost in the Court of Appeals. In the Court of Appeals, they made the argument that they substantially complied, and that's why the Court of Appeals opinion is written the way it is, going
That
through
the
each of the...
PUC order substantially complied.
They argued that they substantially complied. Basically, what the court did, if you look at the Court of Appeals opinion, it went through both the PUC action, what happened to the PUC, and at ERCOT, and it said, look, neither one of these substantially complies, right? Once they lost that argument, then they came here and said, well, it's just not a rule. They always argued it wasn't a rule, but they dropped that part, right?
So you made the statement that the legislature's done the opposite and said this is a rule, so
Right.
help
So
flesh that out.
what it said was that the APA specifically applies to actions under PURA. It specifically applies to these rules. So this argument they make that like every protocol would be a rule, it's simply not true, right? And the Court of Appeals said it's not true. What happened in this case, right, this is the tail wagging the dog, right? What they did was they had a specific rule, 501, about pricing. They had a specific rule, 505, about the scarcity pricing mechanism, right? They wanted to amend those. So what they did is they went, and it says in the record, if you look at it, the staff notes, note that the PUC talked to ERCOT and talked to them about this rule. So then they came back and they proposed a rule, right, this rule, that modifies, it overrides the existing rules. Now they agree that when they passed these rules, and they did it, they passed it through the APA, right, when the PUC did it. And
501 and
501 and 505. The question is, can they amend those rules or override those rules without going through the same process, right? That's the problem here. It's not that they have a protocol, it's that they have a protocol that changes the rules that existed under the PUC. And so there's two basic things to think about. First off, is it a rule, right? They admit it's a rule, right? They admit that it was passed through a rulemaking process, right? And it satisfies all the requirements of a rule, right? It implements a new policy, it prescribes a new policy, it amends the existing rules, right? It is a rule. But then, I was reading the other day Chief Justice Heck's opinion in WBD, which I think is one of the most important opinions to look at for this case, right? Because I think this is exactly what they're trying to do. And in that case, what they had was you had field rules, which weren't really rules, right? They called them field rules, but really what they were was they governed individual sort of transactions at different oil and gas, different fields around the state. And those were passed, they were decided through an adjudicatory process, right? And then it went to the Court of Appeals and they appealed through a rulemaking process, through the rulemaking appeal. And the Court of Appeals decided, well, it's a hybrid process, right? It is this adjudicatory process, but they really kind of make up a rule, and so we're going to allow you to appeal through this rulemaking process, right? And the court said that's just wrong, right? There are two ways to judicial review under the APA. One is through a contested case, when it's an adjudicatory process. The other is through a rulemaking, right? And they said that was an adjudicatory process. You can't take an appeal from a rulemaking from an adjudication. Here, they admit this is a rulemaking, right? When they admit it was done under 151, under the authority to make rules.
Did your client assent to this alternative dispute or rule development process, I guess is what you would term it, by agreeing to be bound by ERCOT protocols in connection with receiving the ability to become a market participant?
No, Your Honor. Even if they wanted to, they couldn't override the statute. The problem here is They want to ignore what the legislature did.
They couldn't override the statute, but could you waive compliance with the ABA through agreeing to be bound contractually by this other
No, I don't think we have the ability to.
other dispute resolution process?
Right. I guess there's two parts to your question. First off, I don't think we can waive the rights under the APA because they're not really our rights. It's the public's right to notice and comment. But in terms of the appeal process, right, the legislature passed Senate Bill 2, which it said dramatically was designed to change the governance of ERCOT and make the PUC responsible for overseeing it directly, which then said, no, none of these protocols are effective until you approve it, right? They've basically refused to accept that that changed the way this works, right? The legislature in Senate Bill 2 told them that they needed to adopt a new procedure. They haven't done it, right? When you look at 252, they haven't updated it since 2003. And so under the old rule, right, before the legislature acted, the PUC wouldn't approve a rule. It would just be effective. And then the process we would go through is by filing a contested case in the PUC. The problem here is the PUC has already acted. The PUC has already adopted this rule when it approved it. So the question becomes, and the Sunset Commission noted that this was a confusing issue because they refused to update their process. What do we do once the PUC has already acted, right? What they're saying is we're required to go back and do a contested case to the PUC about its own decision. That's nowhere in the rules. It's not in 251. It's certainly not in the statute.
Well, an interested party can bring a contested case.
But it's a contested case over an ERCOT action. The PUC has already decided. Now, the best case.
It would be a challenge to the order approving the ERCOT action, I think, is their position.
So we would be filing an appeal to the PUC challenging ERCOT's action of the PUC order that approved it. I mean, the problem is the statute says when the PUC, when the agency adopts a new rule, we have 15 days to file a notice of appeal. They can't abrogate that, right? Their process, the old process, says they don't even have to file a response. I believe it's for 35 days. I don't have it in front of me. But by the time we go through that process, they would be standing here arguing that we've waived our appeal because we didn't bring the expedited appeal. I mean, the legislature's rules are clear here. It says if you want to challenge the validity of a rule, you have to bring a quick appeal to the Court of Appeals so we have that validity challenge decided. That's exactly what we did. Now, their argument is, going back
what is there about the process that ERCOT followed that sort of resembles, an APA type process? What is there about that process relative to the APA process you're saying the PUC should have followed that prejudiced or harmed you?
Your Honor, I would defer to the Court of Appeals opinion because it goes through the whole litany. But beyond that, what I would say is it doesn't satisfy the APA because it doesn't have public participation and notice and comment. I mean, here's the crux of it. I mean, what the court said was for any rule to be effective, the whole point of the APA is if we're going to apply rules to the people, then the people have to have notice and an ability to comment on them before they're applied, right? If it is a rule that the agency is applying. Now, their position is we don't want to do that. We don't want to go to the public and tell them this policy we adopted during Sturm Uri, that's going to be our policy going forward. They could have done this through a rule, right? I want to make sure the court knows this. They talk about the time process. They amended the scarcity pricing mechanism effective June 14th, 2021. The same day they submitted this rule for the 15th, they submitted this change on the 14th. It was passed on the 15th, signed on the 16th. On the 14th, they had a rule process that went into effect, and it was the one that decoupled the LCAP from gas prices, right? They could have done this the way they're supposed to. They chose not to. And if you accept that they can do it that way, then every amendment to every rule will be funneled through ERCOT so they don't have to comply with the APA. And then we don't really have a market and we don't really have an APA.
What's your response to the argument they make that if we go the other way, then all of these orders going back in time, however many he said they came up with, are all void?
And like I said, Your Honor, it's just simply not true, right? The way this is supposed to work, and Your Honor, I think
Yes.
the way this is supposed to work, and the way Senate Bill 2 tried to reaffirm, the policy is the job of the PUC, right? And ERCOT needs to execute that policy. And most of their protocols hopefully follow what the PUC decided. The problem here is we have very specific, very clear rules about how pricing is supposed to work and how the scarcity pricing mechanism is supposed to work. When they adopted this, which in Storm Uri they recognized was an exception to the rules, they're essentially saying what you said, Your Honor, there might be a circumstance where we need to change the way we do business. If they want to do that, it should be through the APA. That doesn't apply, hopefully, to most protocols. It's only when they're trying to themselves create new policy.
Any other questions? Thank you, Mr. Kuhn.
Thank you, Your Honor.
Mr. Heifel, you have 5 minutes.
Thank you. I'd like to start by talking about the substantive PURA point, since we didn't get there before. Of course, the court shouldn't reach this because, in our view, this isn't a rule at all. But let's assume that it is a rule and that we're now looking at the substance of it under PURA. This passes muster under PURA for a couple of reasons. First, it's consistent with the legislature's policy decision that the market be competitive. All this order is doing is helping to ensure that in extreme emergency load shed situations, the price of electricity reflects market realities, and that we don't have a repeat of what happened during Winter Storm Uri, when customers who had been disconnected because of ERCOT-ordered load shed to preserve the grid weren't being treated as demand, and thus reserves were being overestimated. But second, even if the court disagrees with that, it's still lawful under PURA because PURA promotes other values, not just competition. And we talked about this at length in the briefing, both in this case and, of course, in the Luminant case that was argued in January. And as some of the questions, I think, from Justice Bland were getting at, in Section 39-151A2 and subsection D, ERCOT and the Commission are charged with preserving grid reliability. This is also a value that the legislature has charged these entities with doing, and the order here promotes grid reliability because having high prices in times of extreme energy scarcity, it encourages generators to run even at great expense, for example, if they have to buy more natural gas. It discourages commercial and industrial use, and it encourages further investment in additional generation capacity because investors are confident that they'll be able to recoup their expenses during times of scarcity pricing.
I think the notion is, though, that achieving that balance is a policy judgment. And so the nodal protocol process is not the appropriate place for making that kind of determination.
So this gets to something else, which is that there's a distinction between the whole existence of the scarcity pricing mechanism, which is a rule that was adopted by the Commission under APA rulemaking. And then there's the implementation of the details. What is that going to look like? There are tons of mathematical formulas in the ERCOT protocols. So how is it going to be implemented? All that this order does that approves these protocols is that it adjusts that formula. It doesn't actually amend something that's in 25505.
So, okay, so you disagree, you don't concede that the protocol at issue, the ERCOT protocol at issue, amends Rules 501 and 505.
That's correct, Your Honor. Now, it does amend the protocols, which have to do with how that's going to be implemented, but it's our position that it was a pre-existing expectation, I would call it, that as reserves drop, the price of power goes up until eventually it trades at bowl, the value of lost load, which at the relevant times was administratively set at the system-wide offer cap. Again, the court doesn't need to get into any of that in our view, but that's why it's valid under PURA. And again, if the Court of Appeals and the respondents are correct about how this works, there are going to be serious consequences. The out-of-market actions that ERCOT and the Commission take to preserve basic grid integrity, to restore power to Texans during emergencies, are going to be threatened, including load shed itself. And of course, respondents make efforts to distinguish it, but they haven't really given a principled way, because when ERCOT is forcing people out of the market, that's going to affect demand, it's going to affect scarcity, and it's thus going to affect the market price. And they don't deny that load shed is lawful, and they don't deny that load shed was necessary to prevent a weeks-long or even months-long blackout back in 2021.
So what is this process supposed to look like? You said a market participant can appeal to the PUC from an ERCOT board order regarding an NPRR, and then the PUC rules also allow for review of ERCOT nodal protocol changes. But if the PUC is having to now statutorily approve the change, how do those two things work together? Those seem inconsistent to me.
There's even despite the requirement of the approval, the other part of the process will still do the same thing. So after ERCOT adopts...
Does it just ignore that the approval occurred, though, or pretend like it didn't happen, or what happens?
No, Your Honor, Mr. Chief
Yes.
Justice. So after ERCOT adopts the protocol, respondents could have filed their complaint about that protocol revision in the commission. The commission has the authority under 22-251 to put the brakes on the rest of the process, allow that contested case to proceed. Now, let's say they didn't do that.
Before they do their approval.
That's right, but let's say they didn't do that. Let's just say that they power on ahead. Well, then that's something that can be challenged through the contested case, and it is subject to judicial review under 15001 and 39003. The decision to, despite the fact of the contested case, to just plow on ahead with the approval, and the courts can reverse that if there's not substantial evidence to support it. If there are no further questions, we ask that the court reverse.
Any other questions? Thank you, Mr. Heifel. The case is submitted, and the court will take a brief recess.